Well, hello everyone out there, veterans, DKV employees, everybody watching. Welcome back to the Veteran Lang YouTube channel where we talk about VA disability. As always, I'm your friendly VA accredited attorney, Matthew Lang. Hey, we're gonna get relaxed today. I'm gonna put the purple shirt in the wash. I'm just gonna wear my little collared shirt here, little polo, and we're gonna talk about this VA disability a little bit more. But we're gonna do it in a little bit more of a fun way. I'll just kind of go into a game that I call Truth or Myth VA disability. What I'm going to do here is I want to read some statements, and these are statements that are taken from rules and laws of the VA disability world, taken from things I've heard, questions that I've received, and then I'm going to ultimately ask you, veterans and dedicated VA employees, whether you believe it's a truthful statement or if the statement is myth. I'll follow up with a little bit of explanation so we have some additional learning with it, but let's see how many you get right. So let's start with number one. If the VA denies your disability claim, you can never reopen it. Is this truth, or is this a myth? If the VA denies your disability claim, you can never reopen it. All right, got your answers locked in? Well, here's what I'm going to tell you. This statement is a myth. It is not true that if the VA denies your disability claim, you can never reopen it. In fact, you can. For example, a supplemental claim, high-level review claim, maybe a Board of Appeals claim. These are all actions that ultimately reopen your claim either by appeal or later on with a supplemental claim. Let's try number two. Here's the statement. You have 1 year from the VA's decision letter to appeal. Truth or myth? What do you think? Truth or myth? You have 1 year from the VA's decision letter to appeal. All right, got that one locked in? Let's see how well you did on that one. I'm going to tell you that this statement is true. You do have only 1 year from the VA's decision letter to appeal. Now, you have 1 year to preserve that effective date. So now, some people are out there going, well, no, it's not true, it's a myth. Well, yeah, I understand you can file a supplemental claim more than 1 year after. But the idea is that's more of a old-fashioned reopen claim than an appeal, even though it's on an appeal type form. So keep in mind, the VA decision letter that goes out that notifies you veterans of the VA's decision, you have 1 year to preserve that effective date. You have 1 year to appeal that decision. After that, the effective date is going to reset. So if you take a break, it takes you 1 year and 1 day, you'll lose that effective date. So keep that in mind. You only have 1 year from a VA's decision letter to actually appeal. Check out those letters too. You'll see all those appeal rights added into those letters, and I'll kind of explain that to you more. All right, we got 2 down. Let's do number 3. VA must give the benefit of the doubt if the evidence is equally for and against a veteran's claim. Truth or myth? What do you think? Truth or myth? VA must give the benefit of the doubt if the evidence is equally for and against a veteran's claim. All right. Here's what I got for you. I'm going to tell you that statement is true. That's a truthful statement. So underneath the United States Code and the Code for Federal Regulation, the VA is required to resolve reasonable doubt in favor of you veterans. So if the evidence is what we call an equipoise in this case, then yes, the benefit of the doubt should apply. So truthful statement. All right, how are we doing so far? We got 3 down. I'm hoping VA you're getting them all right. I hope you got them all right. Let's try number 4 here on my list. If a condition isn't on the VA's presumptive list, you can't win service connection. Truthful, or is it a myth? Is it truth or myth? If a condition isn't on the VA's presumptive list, you can't win service connection. All right. Thought about it for a little bit? You got your answer locked in? We're ready to get 4 in a row, right? Well, here's what I'm going to tell you. That statement is a myth. Whether the condition is on a presumptive list or not, veterans, you can prove other theories like direct service connection with a medical nexus evidence, or even with other evidence that's allowed by law to prove your case. One thing I'm going to add to this is that you may even claim veterans a condition that's not on a presumptive list due to maybe even a presumptive type issue, say, oh, I don't know, Gulf War, burn pits, Agent Orange, things along that line. So even though it may look like a presumptive issue or on the front end, you can still prove it through direct service connection, especially with medical nexuses, exams, and all the other required evidence. So I would say, as it's written, if a condition isn't on the VA's presumptive list, you can't win service connection is definitely a myth. All right. Well, let's look at number 5 here. VA examiners must provide both a medical examination and an opinion when needed for service connection. True or myth? VA examiners must provide both a medical examination and an opinion when needed for service connection. Well, I'm going to tell you my answer on this one is going to call that one truth. I'm going to call it truth because the law requires adequate examinations and opinions in order to establish usually that nexus between the current service connection and the in-service occurrence or event. So I'm going to call that one. I'm going to call that one true. So we got 5 down. 5 down. How are we doing? VA, you still got 100%. Veterans, you got 100%. Some of this I think can be definitely easily misunderstood. So I'm hoping you got 100%. But if you don't, no worries. No worries. We can definitely learn some more. Feel free to always throw in the comments there anything that you have thought of or that came to mind as you went through these and answer these truthful or mythful questions and statements. So let's move on to number 6. You must be injured in combat to get service-connecting disability benefits. Is it a myth or is it true? You must be injured in combat to get service-connected disability benefits. All right, ready for this one? Kind of rushing you on this one, and I apologize, but this one I think should be a little bit easier for most. So you must be injured in combat to get service-connected disability benefits is a myth. Any in-service injury, disease, or aggravation, not just combat-related, can qualify. So combat is not a mandatory requirement to receive VA disability. All right. Number 7 here. If your condition worsens, you can file for an increased rating. Is that a myth or is that true? If your condition worsens, you can file for an increased rating. All right, ready to get another one right? Well, I'm going to tell you that one's true. Veterans, you may seek an increase anytime there's evidence of worsening symptoms of your condition that's service-connected. Now, many times you can just give a statement saying it is worsened, and VA is likely to do an examination to determine the level of severity. But you can also submit additional evidence to show that the severity of your condition really has worsened as well. So you can do that anytime during the process. Anytime you can file for that increase. All right, number 8. VA can reduce your disability rating without giving you notice. Is that true or is that a myth? VA can reduce your disability rating without giving you notice. And this one's something that we've actually had in other videos before too. So I'm hoping everybody gets this one right. Well, let me give you a second there. Let me give you a second to think about that and lock in your answer here for number 8. So what did you all come up with? Well, I would say if you called that a myth, you're correct. So VA can reduce your disability rating after they give you a notice. So remember, that's due process. You are entitled to due process underneath the Constitution. So the statement reading as VA can reduce your disability rating without giving you notice would be a myth. It would be incorrect. They have to give you that notice. So due process protections, again, you can also find those not just in the Constitution, but in the CFR, in the United States Code. It does require advance notice before, well, most rating reductions, but it does require advance notice. So they cannot reduce without notifying you. Number nine. A claim for PTSD is considered a claim for any mental health condition diagnosed. Is this truth or is this a myth? I think this is a good one, actually, because I see this even via, you may get this one incorrect too. I hope you don't, but I have seen this error in some decisions when it comes to whether this statement is a truthful statement or a myth. And we've had to argue this a few times. So a claim for PTSD is considered a claim for any mental health condition diagnosed. That's our statement. Now that we got our decision locked in here, I'm going to tell you that that is a truthful statement. So the courts have held that VA must consider all reasonably raised mental health conditions. So veterans, if you claim PTSD, for example, and maybe the exam comes back and says you don't actually quite have PTSD, maybe you have, I don't know, major depressive disorder. Well, it says that because you claimed a mental health condition, and one got diagnosed, even though it was different from what you claimed, the VA must still consider both of those conditions claimed and, well, what becomes reasonable or reasonably raised by the diagnosis. So VA can't just deny PTSD in this case, veterans, and VA, remember, please, you've got to look at the other diagnosis too and address that one as well. So in a sense, you would likely see potentially two different decisions on the same decision, on the same VA rating decision, their veterans, when you get it. It could be that they combine them together in one decision as well, but you could potentially see PTSD and major depressive in this example both on there. But the point for this statement is that that a claim for any mental condition is a claim for all. All right, we've gone through 9 of them so far. I'm going to throw you a 10th one in here. Let's see what you think about this one. So lay statements, like from you or your family, veterans, don't matter because they aren't medical evidence. Myth or true? True or myth? Those are the two choices you have. So again, lay statements like from you or your family don't matter because they aren't medical evidence. All right, now this one I want to really highlight as well too, because I think there's some errors that we see in a lot of decisions with this one as well. I'm going to tell you that the statement is a myth. So just because veterans, you provide a lay evidence, as long as it's competent lay evidence and it's observable symptoms, it definitely can establish things like continuity of symptoms or in-service events, or even speak to how a condition affects your everyday living. It's evidence. It's definitely got to be considered, and it does matter underneath the rules and laws. Even though it's not medical evidence, it's still evidence for your file. So, as the statement reads, lay statements like from your family, you or your family, don't matter because they aren't medical evidence would definitely be a myth. Now, I highlight the importance in this one because I've noticed in VA, I'm gonna give you this as a teaching point from this side of the table, and especially from working within the VA for so long. You can't dismiss those lay statements. The rating decisions I see dismiss these lay statements all the time, and I think this is where this myth comes from. Is like, well, my lay statement wasn't addressed. The VA didn't look at it. VA didn't review it. They didn't even consider it. They never even analyzed it in the rating decision. So they just told me it doesn't matter. Well, VA, you're supposed to actually consider it, talk about it, analyze it, and give more conclusionary statements. And that's what our reasons and bases again. And we're going to highlight those even more in other videos in the future. But I believe we've hit on it a couple times briefly. So keep in mind, lay statements do matter even though they're not medical evidence. All right, so we've done 10 here so far. I'd be interested at some point after the video, especially if veterans, you commented, VA employees, if you feel like commenting, just kind of give me an idea of what you think about our little game here. I want to add different dynamics to our channel. At the same time, don't forget, veterans, you can always reach out to me. If some of these come across and you go, oh, I didn't realize, and I think there's an error in my last decision from the VA based upon something we've covered here today or any of our videos. Remember, veteranlane.com. You can get on my calendar, schedule some time to talk with me. We can see how we may be able to help. We can get on record if we need to. We can represent you if that's the right direction to go. We can then start reviewing your case. We can advise you on what's needed. We can put together those arguments. We can help to kind of explain to the VA what went wrong in the decision process and get them to fix that for you ultimately in the end. So don't forget, there's always help out there. Again, veteranlang.com, right to my calendar to schedule some time with us. All right, I don't want to take up a whole lot of your time today with the video. I've done 10 on there. I actually wrote up 20 of them, but I think that might go too long, and I don't want you yawning too much on me today. So let me scroll through here. Let me flip through my pages. Let's find just a couple more. Let's throw in a couple bonus questions. Let's see how you do, see what you think. And then, if everybody enjoyed kind of this here, we'll definitely do it again in the future and cover some more of these. Oh, here we go. Let's do this one. Here's your bonus number 1. If you have multiple disabilities, VA just adds the percentages together. True or myth? And here it is again for you. If you have multiple disabilities, VA just adds the percentages together. Well, for anybody who's had a VA claim, or even if you work inside the VA, I think you should recognize right away that this one's a myth. VA doesn't just add the percentages together, because a lot of times, if they did, veterans, you'd probably find you're 200 or 300% disabled. Remember, VA uses a combined ratings table underneath the CFR. It's not simple addition, and we call it VA math. We've also done a video on that too, and kind of my version of how you can kind of calculate that out. A little probably hard to follow for some, so we might readdress that in the future, but just know that there's a video out there to kind of give you an idea of what that VA math looks like. So feel free to go back in our archives here and our other videos and check that out again, and check it out for the first time if you haven't seen it. All right, I hope you're all doing well. I hope you're getting all right answers, but again, if you're not, no worries. That's what we're here for. We're here to educate. We're here to learn some more. So let's throw in a couple more. Let's just do 2 more bonus ones here really quick. This one I like. This one's a good one. This is another one we see some errors on. Tell me if you think this is true or if you think this is a myth. Yell at your screen. I might hear you. No, I'm just kidding. Here's the question or the statement. Missing a VA exam automatically means your claim will be denied. Is it true or is it a myth? Missing a VA exam automatically means your claim will be denied. Well, guess what, veterans? That statement is a myth. Hard to believe, right? Yes, I know. VA, it's a myth. I'm going to highlight this one because we see this all the time. There will be times VA, you'll schedule exams and yeah, maybe a veteran doesn't show. But that's not an automatic denial, even though that's what we see in the good, the bad, the ugly kind of portion of everything, or mostly the bad and the ugly when it comes to the decisions. Veterans are told you didn't show for your exam, and that's the only reason we're denying if you really read that decision out the way it's written. So remember, the claim has to be decided on all the evidence of record. Everything's got to be analyzed. Everything has got to be laid out there. The idea is the exam may not even been needed in order to make that decision, and so not showing up to it had no bearing or any real weight to a reason for denial. So the point is it is a myth. It is a myth, veterans, even though it may not feel like it in the decisions you get. Missing a VA examination does not automatically mean your claim will be denied. Now, on the other side of that, though, as we mentioned before in one of our other statements in here, that examination may be required in the end to actually make that determination of granting your benefits, whether it be an increase or service connection. So do note it can still be denied for not showing for an exam, but it's not an automatic denial underneath the law. All right, one last one. Let's do it. Let's find one last one in here. Let's see if we can find another really good one to talk about. Oh, I like this one too. There's so many good ones on here. I almost want to still do them all, but let's do this last one. Last bonus one for you. Number 3, bonus number 3. If VA treatment records exist, VA has a duty to obtain them, even if veterans, you yourself, don't submit them. So what do you think? If VA treatment records exist, VA has a duty to obtain them, even if veterans, you don't submit them yourself. True or myth? Do you have to submit all your evidence, veterans? Or does the VA have a duty to obtain some of this evidence? Well, I think when we think about that, we'll find that this statement here is true. VA does have a duty to obtain your VA treatment records. So the idea here is that the duty to assist underneath the United States Code and the Code for Federal Regulations requires the VA to obtain relevant federal records. And I think what's really fascinating here is the idea that you're like, but it's the VA's own records. And you're right, it is. Remember, the VA is one big umbrella as the Department of Veterans Affairs, and then we branch down in 3 different spots. So we do have the benefits office where your claim is going through, and we have the healthcare office. So these records that you go through treatment for, you get your medical side in the healthcare section, all are separated from the benefit side, but they are still a relevant federal record, and they are in the possession of the VA, technically. So the VA does have a duty underneath the duty to assist requirements of the law to grab those records and put them in your file, veterans, whether you submit them or not as part of your claim. There you go. Hey, I'm hoping that was kind of fun for most anyways, and definitely educational. Just put some of those myths out there, some of those truthful statements as well, mix them in there, kind of get you thinking. As always, the ultimate goal is to just educate and make this process much smoother between veterans and VA alike. If there's anything else you would like to see in the videos, we got still plenty coming. But if there's any topic you'd definitely like to hear about, please throw those in the comments as well. And we'll definitely get those filmed here and that information out to you. I enjoy a lot of sharing all this information and knowledge with you. But again, don't forget, I can't guide you or give you guidance or advice in this platform. It's just not allowed underneath the rules. There is no attorney-client relationship here. This is all educational purposes. So when you do ask questions, I will do my best to give you the educational answer. But if you do want potential advice or representation, don't forget, as mentioned before, veteranlane.com, you can find my calendar. You can get on that and then work with us if we feel that there's something we can help you with in order to get those benefits, veterans, you're entitled to. All right, everybody, have a terrific, tremendous Tuesday if you're already not. And if you are, continue having a terrific, tremendous Tuesday. And we'll see you next Tuesday in another video. Thank you.